supplementary list, item number 1.
May it please your lordship. Before my friends start, your lordship, if I may request your lordship that this matter be taken up tomorrow, your lordship, I'll have instruction in the matter. Tomorrow only, your lordship.
Otherwise, this case was a covered case.
It's not covered, your lordship. I'll make my submission, your lordship. My humble request is, your lordship, if the matter comes tomorrow, your lordship.
Your lordship passed an earlier order. That was in respect to Jayanti Hills, my lord, but law is same, my lord. But this is
it's not covered, your lordship. I'll place my case, your lordship. Tomorrow, your lordship. Highly apply, your lordship.
On permit by the Red AG, appearing for the state respondent.
125, your lordship.
Matter to be taken up tomorrow.
Lordship. I'm highly apply, your lordship.
Item number 2.
Lordship, my senior counsel sitting reached here. It's my humble request to take the matter in the end of the body.
From daily list, item number 1.
Please, my lord. My lord, this matter pertains to payment of land acquisition compensation, my lord. My lord, here for the construction of the Indo-Bangla border fencing at Shela village. My lord, here sometimes in the year 2010, the government had notified that will be acquiring land within the Shela Durbar for the construction of the border fencing. And according to my lord, on the same year, a declaration has been made by the government. The pursuant, my lord, to the declarations and the notifications, several representation has been filed before the collector. My lord, we have also indicated that any payment of compensation shall be received under protest. Then, my lord, what happened is that in the year 2013, a reference was made by the collector under section 18 of the LA Act, of the old Act. Then, my lord, in the year 2019, an order has been passed by the judicial officer, my lord, by the special judicial officer, where, my lord, the reference has been returned to the collector to ascertain as to the disputes whether the same is with regards to the interest of the land or with regards to the fair payment of determination of the compensation. My lord, that order is at page 90 and next year 12. Page 90.
90?
90, annexure 12.
Yes.
Well, the operative part is at para 23, page 95. This is the direction, my lord.
Yes.
Para 23. This reference is sent back to the collector, who will take necessary steps by identifying the dispute, if it is with regard to the interests on the land or with regard to determination of fair compensation. The reference being sent back shall not bar the collector from making fresh reference after identifying the terms of the reference. Now, my lord, pursuant to this order, pursuant to these directions given by the special judicial officer, the respondent number 2, my lord, who is the Additional Deputy Commissioner of Revenue, by letter dated 25/8/2021, has directed the respondent number 3 to cause an inquiry, my lord. That is at page 96, my lord.
Yes.
My lord, after this, nothing has happened. As to what was the inquiry, what was the steps taken by the respondents, nothing has been forthcoming, my lord. Now, against these inactions of the respondents, the petitioner number 2, my lord, has sought for an RTI as to what steps has been taken by the respondents and whether any award has been made in respect of the said acquisition proceedings. My lord, that's at page 97 of my writ petition. As your lordships can see, several queries has been made. Firstly, my lord, whether any award has been made by the collector in respect of the said acquisition proceedings. Now, your lordships will see their reply they have simply stated that land compensation was partially paid to the landowners, except for those where the verification report of the claims and counterclaims of the rightful owners is still awaited from the office of the respondent number 3. It has nowhere indicated, my lord, whether an award has been made in respect of the said acquisition proceeding. And the lordship is very much aware that an award has to be made under Section 11 of the LA Act, my lord. And the time prescribed is for a period of 2 years from the date of the notification. No, my lord, here, this is a case where, till date, no compensation amount has been paid to me, where it's been clearly indicated that some land owners has already been paid the payment of land compensation. Now, lordships, when there's no award has been made under the old Act, then, my lord, the respondents ought to take fresh steps and issue fresh
You mean to say that
notification.
there was no process of the land acquisition in taken
Well,
up.
yes, there was a process they have issued, but the question, my lord, here,
Section 4, Section 6, all
yes,
complied
all
with.
has been complied, my lord, but only thing, no award has been made.
No orders.
No award has been made.
Have you been notified as one of the
My lord,
interested
yes,
persons?
your lordships kindly
What is that initial
can we
notice?
have page 71, annexure 6. This is the declaration, ma'am. Your lordships, can you have next page, page 72? These are the list of the beneficiaries, my lord, and my name is indicated as serial number 8 and 9.
This copy is not clear.
I've provided my lord, the type copy.
These, serial.
Serial number 8
Serial
and 9,
number
my
is
lord.
not
JJM Nichols Roy.
Okay. So what is your grievance?
No, my lord, my grievance is that, firstly, my lord, I'm before your lordships for directing the respondents to pay the compensation amount payable to me. And secondly, my lord, if no such compensation has been made, or whether no award has been made, a fresh acquisition proceedings has to be taken by the respondents in terms of Section 24 of the new Act.
Is there no provision under the Act for to resolve such issues?
My lord, your lordships kindly have Section 11.
See, if you say the stage has reached to a point where Section 4, Section 6 have been complied with,
Yes.
now only the award has been determined.
Award has been determined, my lord.
Now it's only for disbursement.
My lord, yes.
You are concerned with that.
Yes.
That the award has not been, finally given to you.
Yes.
There must be some provision.
My lord, here,
Yes,
after
Mr. Sen,
my-
what do you say? You are a collector.
My lord, I'm querying for the respondents. Please have page 88 of the writ petition. My friend's case is that no award has been drawn up as on today. Page 88 is the reference order which has been drawn up by the DC. Please see this, my lord. Whereas so-and-so, SDCMA Nichols Roy, and these are the names of all the other landowners, has not accepted the award. So it therefore means that award was drawn up. My friend's case is that he filed an RTI, and in response to the RTI, there was no mention of an award. That does not mean that the award does not exist. So award does exist. They were offered the amount of compensation, but they refused to accept it. Perhaps because they felt that the amount was insufficient.
But he was saying, in that process,
My lord.
reference was made under
Yes.
Section 18.
Section 18.
Correct.
So the reference would cover this part.
Yes, yes. The court found that there was no cause for a reference and sent it back to the DC to re-examine the matter. Now, thereafter, I don't know what's really happened. I'll have to obtain instructions.
You see,
Yes, yes.
Now, you are referring to some even which has already taken place,
Yes.
already covered.
Correct.
So it doesn't help you. It's neither here
No,
nor there.
there's one of his cases. One of his claims is that there is no award, so therefore the proceedings have lapsed, and now there should be an initiation of proceedings under the new act. But page 88 itself indicates that there was an award,
Oh,
and
that-
the award
that has
sum
been-
was deposited with
that
the
has
court
been
as well.
covered by the order of the Leonard Special Judicial Officer.
My lord.
So you.
So I'll
you
take
seek-
instructions.
seek instruction.
Lord.
In the meantime, you accept notice.
Yes. All the respondents.
All the
One, two,
Two
and three.
respondents, my lord. 1, 2, and 3.
Heard, Mr. CCT Sangwal and counsel for the petitioner. On consideration of the submission made, this petition is admitted. The notice upon the respondents, formal notice on the respondent is not required to be issued since the respondents have been duly notified and has appeared before this court through Leonard Additional Senior. You are
GA,
J.
my lord. GA.
Through Leonard G. Mr. S. At this point of time, before formal filing of the affidavit in opposition, the Leonard G. has submitted that he might be allowed some time to seek instructions as far as the status of this of the matter is concerned. Accordingly, this is matter up to 2 weeks.
Obliged, my lord.
Item number 2.
Yes. As far as the union is concerned, what is required is for this court to know what is the stand of the government, the central government for that matter, what steps have been taken, and of course the process will follow, because there's only a process indicated under the Foreigners Act as far as foreigners are concerned. But the only thing is that has caused concern to this court is what is the condition.
Specifically for as to even if they are granted bail,
Yeah, what would be their
person or they have to detain someone.
that is the
My lord, in this matter, my lord, there is some subsequent development, my lord. So I'm praying lordship may allow me to bring on record all those developments.
what developments.
Yes, we have been informed that, my lord, the bail has been granted by the trial court, my lord. So, my lord, we are not fully confirmed, my lord. So I'm praying if this matter can be taken up day after tomorrow, my lord.
But why have you preferred?
No, my lord, it is a default bail, my lord, I think. We are also not yet confirmed, my lord. So I'm praying if lordship may fix it day after tomorrow, my lord.
So when do we?
Day after tomorrow, my lord. We'll place the, if any bail is granted, my lord, we'll place it the order, my lord.
दान करेंगे on pre-made by Ms. Nana Counsel for the petitioner, who has sought for some time to seek instruction as to seek instruction matter is accordingly adjourned. List the same on 27. Well, if that is the case, then
Nothing survives.
if the case is out of this court, nothing survives. But
Issue remains.
the issue will remain.
That's the, my lord.
One way or the other, it will come up before the court. Bye.
Blessed.
3.
Malad, 3 is connected. Connected. 2 and 3.
2, 3, save 4.
Item number 4.
Please, Your Lordship. Lordship, this matter, respondent number 2. For respondent 2, my lord, we have filed an affidavit of service. Other respondents, my lord, number 1 is appearing, contesting. And number 3, my lord, also affidavit. Oh, there is no 3, my lord. Only 1 and 2.
So according to you, notice has been affected on the respondent too?
Yes, my lord. As per the GPO's report also.
You're appearing for?
Respondent number 1.
Mr. S. General Counsel for the petitioner, for the appellant. This is a miscase
It's a miscase, my lord.
for the applicant. Has submitted that the notice issued upon respondent number 2 has been affected. However, some time is prayed for the affidavit of service to be filed.
We have filed it, my lord. We have
filed?
already filed. It was filed on 19th, my lord.
Then what is your prayer?
My prayer, my lord, is that matter can proceed further. The condonation is pending. Condonation petition, it's a delay of 5 days, my lord. That may be condoned.
Where is your affidavit of service?
It was filed on 19th, my lord.
Oh, this is the one you're supposed to take the certificate from the
Yes.
post office.
It's been attached.
Has been affected, nahi? And to this extent, an affidavit of service has been filed before this court. Affidavit of service dated 19/2/2025 has been filed before this court. Till date, the respondent number 2 has not made his appearance before this court. We'll list this matter on Monday for ends of justice. This court deems it proper to await the appearance of the respondent number 2. Accordingly, this application will be taken up for hearing on the next date fixed. That's the same on Monday live. This is matter on 3rd.
Item number 5.
Yeah, this is the hearing matter, isn't it?
Yes.
So we'll just go back to the first
Main list.
come back to you.
Right. Good.
Second call from supplementary list, item number 2.
Yes, miss.
Lordship, Lordship, I am ready to withdraw, Lordship, but just one judgment I got, Lordship, which is from Supreme Court, Lordship, where the advocates moved for the cancellation of bail, who is, even in the heading it is mentioned as who have nothing to do with the case. In the head notes it's mentioned. Here in para 11, it is mentioned, though the aforesaid petition has not been deviated from by the division bench of the Madras High Court, it is necessary to remind all concerns of the legal principles involving the prerogative of a Chief Justice. The division bench has gone wrong in holding that the petition submitted by the concerned advocates was not maintainable at all. Refusing to exercise the suo motu powers contemplates in section 439(2) cannot be on such a fallacious premise. The division bench ought to have considered the petition on merits. Lordship,
Exactly. You see,
Lordship,
what you are essentially saying is the court failing to take necessary steps as far as the provision of 439(2) is concerned.
Lordship,
That is the suo motu
power of the court. Lordship, previously also I have stressed on that.
that will have to be on facts and circumstances of the case, and it is very clear. You go through a number of Supreme Court judgment on this issue as far as cancellation of bail is concerned.
Lordship,
Once bail is granted, to cancel it would be very difficult, except where it is apparent that the accused concerned has violated the condition. If you can prove that yes, he has violated this, failed to cooperate with the IO, not then threatening witnesses, so on and so forth, then even the IO can move the court concerned for cancellation of the bail.
Lordship,
Or if you say so, even the counsel can apprise the court of the situation and the matter will be taken up.
Lordship.
But this is not the case here. This is not the case, and you are a complete stranger to the case. You are not even, you see.
Lordship, here the advocates who are advocates in this case, advocates also are the strangers. Advocates has nothing to do with the case. Lordship, in this case,
he must have been the advocate of the party concerned or the complainant or whatever. We don't know.
we don't know, but Lordship, here moved by the advocates who have nothing to do with the case. It is Lordship. Furthermore, Lordship, I am just to apprise Lordship that here the main problem is with regard to the tax money, Lordship. It's the legal remuneration of entire we are myself. I am not aggrieved alone, Lordship. It's the government, and the government taxes are being not paid.
So let in that case, let the government take steps. There are ways and means. You see, there are procedures to be followed. That will be done. If it comes before this court or any court for that matter, it will be taken up. It is not. You see, the court is not, close to the fact that if an injustice has been perpetrated, it has to be remedied. But everything has to come through, like you say, through proper channel. You cannot just short circuit the process. You cannot just intervene as a busybody. That is exactly some of the expression that is used in cases of this kind. So we'll see. You pursue your remedy elsewhere. Yes, we will study. Learned counsel for the petitioner has submitted that on instructions, this petition may be allowed to be withdrawn to allow the petitioner to follow other course of action. That will do.
Lordship.
On submission so made, this petition is accordingly withdrawn with liberty sought for allowed. Dispose of. May withdrawn, dispose of with liberty. Thank you.
And the release item number 6.
What we will do, since I have another, have another bench, we'll continue till whatever time permits us, and perhaps we may have to continue the next day.
Yes.
Because I have another DB today, so I don't know if that DB may sit in the afternoon.
Yes. We can do that. We can do that. Yes.
We'll see.
Yes.
But again, hearing in, I have thought about it.
Yes.
In fact, if I remember correctly, Mr. Jindal has already almost completed his
3/4. 3/4 is over.
Sad thing is I've forgotten.
Or even including us also.
Even I have forgotten.
My pen has to refresh.
So now he refresh. We take it up another date. Then
this will go on.
He has to refresh on what has been refreshed.
That's why
it would be better cases of this kind, to be at one go.
Yes, yes.
That's why, my lord, on the last occasion, if lordship recalls, I had made a small prayer that this matter, whenever convenient, may be fixed at 2 o'clock.
I understand that.
Just to give us the 2-3 hours continuous hearing.
But today it so happened that
yes, madam. Yes, madam.
Right.
The list just came yesterday.
Right. Even lordship, we may continue tomorrow or day after tomorrow, subject to lordship convenience.
Yes, that can be done. But even then, tomorrow, so we still have 2 DB.
Yes.
Criminal bench will be sitting tomorrow, as of and also today. What do you propose?
My friend may start today, and subject to lordship convenience may continue day after tomorrow, if there is a matter that's scheduled tomorrow. Then after 1-2 days gap, then in that process, I think we will finish the matter.
Please, your lordship.
Please.
My lord, what is before you, my lord, is a second appeal filed against judgment passed by First Appellate Court. Now, I'll have to go a little back into the background. The case, the fulcrum of the case, my lord, arose long back in 1923 through the execution of a lease deed in our favor, that is at page 14 of the paper book, my lord. 14 of the paper book. Fourteen.
Yes.
This is a lease deed executed by the respondent. Executed by respondent in our favor for a certain area of land, my lord. Now, my first request to this honorable court is to kindly appreciate that there is no controversy or dispute as far as this lease deed is concerned, as far as to the execution of this lease deed. Both parties, my lord, are ad idem of the same mind that yes, this is a valid lease deed, validly executed, and it exists and binds the parties. This fact, my lord, is important in view of what the First Appellate Court's judgment has held in respect to this lease deed. First Appellate Court It was no one's case, but First Appellate Court has declared this entire lease deed as invalid. It was no one's case before the First Appellate Court, my lord. In any event, if Lordship allows me to point out certain aspects from this lease deed, firstly, my lord, the second paragraph may kindly be looked at on the first page 14 itself.
Yes.
The respondents, my lord, does hereby lease in perpetuity.
Yes.
So the first aspect is it's a lease in perpetuity, my lord. The said land covering an area of 10.19 acres. So the lease was for perpetuity, covering an area of 10.19 acres, more or less from 1st April so-and-so to the General Secretary Sports Section, Shillong Club. That is the appellate, my lord. The second aspect, if Lordship kindly turns the page 16. Second aspect is at subclause H. The lessee shall be entitled to relinquish this lease at any time on giving not less than 1 year's notice to the lessor, his heirs, successors, in interest or assigns. Lessee means the appellant, my lord. So we were given the right to cancel or terminate or relinquish this lease. The parallel right was not given to the respondents, my lord, the lessors, my lord. Second aspect. Third aspect, and again important in view of what happens later, the second last line on the same page. The previous lease, which is current till the 31st March 1922, is hereby cancelled. So this document itself shows that apparently there was a previous lease between the parties, which was till 31st March 1922. The date is important, my lord, in view of what transpires subsequently, my lord. This is the 1923 lease. Now, 1923, we were handed over the land. We just started developing the land. Today, currently, the golf course stands on that land. Part of the golf course stands on this 10.19 acres, my lord. There was no problem whatsoever. However, my lord, in 2013, problems started coming up. Page 19, my lord. 19. The first indication of a problem was when the respondent issued this letter on 18th January 2013. Now, I'll skip the first paragraph, my lord. I'll go to the second paragraph immediately. So firstly, my lord, the schedule of the land is reflected. Schedule is there, north, east, southwest. This is the same schedule as per the 1923 lease deed, my lord. After the schedule, that the portion of land on the south, as shown and indicated very clearly in the said schedule above, has never been utilized nor fenced properly, resulting in a massive encroachment. But since the neglected and unutilized portion of land is still remain with our Thank You Like Folk Land as the owners with the trees standing thereon, thereby we have decided to take back into possession the said portion shown above, which is outside of the scheduled leased out to your club and not utilized or cultivated by any person. In this regard, we would like to make necessary arrangement with your club for amicable handing over by your club and taking over possession by a Thank You So and So clan of the said plot within 2 months from the date of receipt of this letter of representation. Furthermore, it goes on, my lord. So what comes out from this 2013 letter is 2 or 3 important aspects, my lord. One, it reflects an intention on the part of the respondents to maybe cancel the lease deed or modify the lease deed. Number one. Number two, my lord, the allegation or the stand taken is that the southern portion of the land has never been used by us. So therefore, they want to take back that southern portion. Now, which part of the southern portion, my lord, because Lordship will kindly appreciate it is not very coherent or clear how much of the southern portion and southern starting from which center point, my lord. It just says the southern portion you're not using, we are taking it back. So the third aspect is there is an implicit agreement from their side that you are in possession, I am in possession. For XYZ reasons, we will take back into our own possession. Now, this was in 2013, letter was issued expressing this intention to disturb the position, my lord. Now, Subsequent to the letter, there were some attempts, there were some advertisements in the newspapers, etc., trying to sell off certain portions of that land, etc. We filed objections with the registrar's office against any proposed sale, etc. FIRs were filed on account of encroachment. These are incidental facts, my lord. The entire matter, it resulted in the filing of a suit from our side, my lord. The suit, my lord, is at page 1 of the memo of the paper book, my lord.
Page
1.
Yes.
Now, my lord will see the nature of the suit, page 1 itself, a suit for declaration, permanent injunction, and other consequential reliefs. The prayer in the suit is important, my lord. That is at page 10.
Yes. Yes.
I'll quickly read the main prayers, my lord. Number 1. Declaration that the plaintiff Shillong Club Limited is a lawful lessee in respect of the suit property and holds the suit property under a valid perpetual lease deed. Number 1. Number 2. Declaration that the defendant or any of his agents, associates, representatives, so and so, claiming under or through the defendant, have no right to disturb the peaceful possession of the suit property or any portion thereof by the plaintiff in any way and by any means whatsoever. Number 3, a perpetual and permanent injunction. It goes on, my lord. The main prayer is, what you would have seen, seeking a declaration that we are the lawful lessees holding the lease, the scheduled land, and consequently, the other side, the respondents, have no right to disturb our possession, our peaceful enjoyment. That is all. We were concerned, in other words, my lord, in very simple terms, we were concerned with only this 10.19 acres. Protect our rights over the 10.19 acres, my lord. This was the suit prayer, the suit filed. Against the suit, my lord, a WS was filed. That is at page 33, my lord.
Yes.
33, my lord, is the WS filed by the defendant, that is the respondent, my lord.
Yes.
Now, fairly standard kind of WS, but page 2 of the next page, my lord, para 14 of the WS.
Yes.
Now, para 14, the second portion, the second paragraph, is where the defendants, the respondents, came up with their version of events, my lord, for the first time. So, Lordship may kindly recall, 2013, it was a very simple claim from their side. Their claim was, you are not using the southern portion, so we will take back the southern portion into our possession. That was in 2013, that letter. In para 14, a new version of events has been put down. If I'm allowed to read the second portion, in reply, it is stated that the predecessor in interest of the defendant on 20th October 1914. Now, this date is important, my lord. This is their version of events. They say on 20th October 1914, the defendants leased 16.91 acres of the land to the predecessors in interest of the plaintiff's club. Thereafter, due to bona fide requirement and on mutual understanding, 6 acres of the land situated to the south of the leased land was taken back by the predecessor in interest of the defendant, and a fresh lease deed dated 20th March 1923 was executed. That is my lease deed, my lord. Was executed only for an area of 10.91 acres as an annexure 1 of the plaint. Few days after execution of the fresh lease, it was discovered that the boundaries of the said fresh lease to the south remained unaltered like the previous one of 1914. The then predecessors of the defendant raised this issue before the then members of the erstwhile Shillong Sports Club for causing necessary corrections to the deed. However, the then members of the plaintiffs club assured that they too are men of words who keep their words as well, and that they would never question the landlord's title nor encroach into the predecessor's land beyond the allotted 10.91 acres on the mere minor technical defect in the document, and the predecessors of the defendant accepted that assurance. I'll just skip, my lord, the last paragraph. since 1923, the said portion of 6 acres remained in the absolute possession and occupation of the defendant and his clan, where he had also leased certain portions in and around the said land to different tenants by issuing pattas to them without any objection from the then members of the plaintiffs' club, as assured by the predecessors. Now, Lordship, I'll pause. So the version of events that was put forth in the WS was that apparently, allegedly, in 1914, my lord, there was a previous lease deed. On 20th October 1914, there was a previous lease deed which they had apparently executed in our favor for 16.91 acres. Number one. Number two, the further allegation is that in 1923, at the time when that 1923 lease was executed, which Lordship has seen, at that time, apparently, allegedly, they took back 6 acres on the southern side of the property, my lord. And that 6 acres has thereafter remained in their possession. They say that they have issued pattas also for certain parts of that 6 acres, etc. Now, my lord, on the face of it, this stand that they have taken does not hold. For the simple reason that if indeed it was true that in 1914, that 1923, you took back 6 acres and that 6 acres has always been in your possession from 1923, then why in 2013 you are saying that I am not using that portion, therefore you will take back that portion, if already in 1923 you have taken back 6 acres?
If I don't know,
Yes,
if I understand correctly,
yes, madam.
What is meant here is, yes, you have executed a fresh deed with regard to that 6 acres plus.
All right. No,
which was inclusive in the the previous deed.
Yes, madam.
But that was notional. In as much as you are still in occupation of the said portion, which was pointed out by the defendant.
My lord.
And then you say that we have a gentleman's word and whatever.
My lord, my point is a slightly simpler point, my lord. That if indeed it was true that in 1923 you've taken back 6 acres, number one, in the 2013 letter you would have at least referred to that fact, and number two, you would have alleged that I'm in illegal occupation of the 6 acres. Nothing of that sort. Your allegation is I'm not using the land, and therefore you will take it back. So, my lord, there is a disparity which is evident prima facie, my lord, on the face of it, my lord. Now, moving on, this was the WS filed. Then the 2013 letter which they had issued, which put them in a spot of bother as far as the defense that they are raising is concerned. How have they tried to explain it in the WS? Para 17, my lord. Next page, para 17 of the WS.
Yes.
That the plaintiff was, I'll read, my lord.
Please.
That the plaintiff was found to have surreptitiously constructed cowshed and other shed, housing the club's chokidar and others to the south of the leased land and on the north of the defendant landlord's land. However, the defendant being a layman and an old-aged person with memories failing him, he was in no position to properly draft the wordings in the said letter dated 18/1/2013. However, the bona fide mistake and innocence of the defendant will not confer upon the plaintiff's club to take advantage over the same like any other opportunist before the court of law. This is in reply to para so and so. So, the defense or the explanation for the 2013 letter was, I am an old man with my memory failing me. Therefore, what I have said in the 2013 letter should not be given any importance, my lord. My lord,
what he means to say here is the earlier assertion that the land was unused.
Yes.
Turned out that the land was used for construction of those sheds.
What appears, my lord, is that according to them, para 17, the 2013 letter was written by an old man with his memory failing him. So that's why it should not reflect the actual position of the defendants vis-a-vis this land, my lord. That cannot be, my lord. That cannot be in 2013. If your memory was failing you, subsequently the same person came and gave evidence in the court also. Therefore, his evidence is to be discarded entirely, in that case. If in 2013 his memory had failed him, what he had written, what he had stated in writing is not to be taken as the truth or the correct reiteration of the facts, my lord. This was the WS file, my lord. Now matter proceeded in the trial court, in the suit court. Evidence was led. Both parties led evidence. One witness each from respective sides. I will not burden this honorable court by going through the evidence. It's more or less a reiteration of the pleadings, my lord. Now, the suit court finally passed its judgment, my lord. The first court passed its judgment. That is at page 112, my lord.
One.
112. Now, this judgment, my lord, was passed on 23rd December 2015, last working day of the court. And this judgment, if I can take my lord quickly through the relevant portions. Page 115, my lord. Page 115, para 7.
Yes.
Para 7, my lord, are the issues which were framed by the learned court. I'll quickly read the issues, my lord.
Yes.
Upon perusal of the pleadings, the following issues were framed by my learned predecessor in office on so-and-so. Number 1, whether the parties entered into a registered lease deed dated 20th March 1923. That is my lease deed. Number 2, whether the said lease deed dated 20th March 1923 was to be a lease in perpetuity. Number 3, whether the defendant, by lease deed dated 20th October 1914, leased out 16.19 acres of land to the plaintiff's club, and thereafter, by the lease deed dated 20th March 1923, reduced the area and leased out only 10.91 acres of land to the plaintiff's club. If so, whether the 6 acres of land situated to the south of the golf club, no longer leased to the plaintiff's club, stood reverted back to the defendant and his clan since 1923. So this, my submission is the most crucial issue, my lord, because it deals with both parties' stand. It asks the question whether there was a 1914 lease deed in my favor, giving me 16.91 acres, and whether in 1923 6 acres was taken back by the defendant, my lord. Fourth issue, my lord, whether the defendant issued letter dated 18th January 2012 expressing an intention, it should be 2013, my lord, expressing an intention to take back into possession the southern portion of the suit property. Number 5, whether the plaintiff's club raised any objection when the defendant leased out portion of the 6 acres of land to the Dorbar Shnong, Golf Link so-and-so, to Srimati so-and-so, Srimati so-and-so, Srimati so-and-so, where they have constructed and taken possession of the property. 6, whether the parties are entitled to any reliefs. Now, these were the issues framed. The findings, my lord, next page, page 116, para 9.
Yes.
Now, issues 1 and 2, if Lordship kindly recalls, issue 1 was whether there was a lease deed of 1923.
Yes.
And whether it was a perpetual lease deed. Finding, my lord, para 9, second paragraph, second portion.
Yes.
Both the parties have admitted to the fact that there was a lease deed dated 20th March 1923 between the parties, and according to section 58 of the Evidence Act, facts admitted need not be proved. Issue number 1 and 2 is decided that there was a lease deed dated 20th March 1923 and the lease deed was in perpetuity. So the suit court agrees that yes, indeed, there was a validly executed and registered lease deed I had entered into in 1923, my lord. Now I'll just pause, my lord, before going forward. Lordship may kindly go back to my prayers. What I had highlighted, and what you may kindly recall, is that my prayer was only in respect of the 1923 lease deed. I sought a declaration that I am a valid leaseholder under a valid lease document of 1923. Issues 1 and 2 being decided in my favor, I would humbly submit answers the questions raised in the suit. It answers the prayers in the suit, my lord. So there would have been or should have been no occasion to go further. But in any event, suit court went further and decided issue number 3 under para 10, my lord. Now, issue number 3 is that important issue, my lord, whether there was a lease deed of 1914 and whether in 1923 they took back 6 acres, my lord. The finding is important. Issue number 3, para 10. PW Shri so-and-so on his deposition on affidavit stated that the lease deed dated 20th October 1914, which is Exhibit A, is not related to the plaintiff's club in any manner, and he has reiterated in his cross-examination that the Shillong Club was incorporated as a limited company and registered under the Companies Act only 1923, only on 1/8/1923. This court also perused the Exhibit A, the lease deed dated 20th October 1914, and found that this lease deed was between the predecessor in interest of the defendant and the secretary to the Shillong Sports Club and not the Shillong Club. This court has also perused Annexure 1 and also perused Papermark A, which is the lease deed between the predecessor in interest of the defendant and the plaintiff club for an area of 10.19 acres of land. After perusing both the lease deed dated 20th October 1914, which is Exhibit A, and lease deed dated 20th October 1923, which is Annexure 1 and Papermark A, this court found, this is crucial, this court found that the lease deed dated 20th October 1914 is not between the plaintiff club and the defendant, but the lease deed dated 20th March 1923 is the lease deed between the plaintiff club and the defendant for an area of 10.19 acres. So, there is no question of the 6 acres of land situated at the south of the golf club being reverted back to the defendant since 1923. Again, my lord, this again should have been the end of the matter. Finding was very clear that in 1914, I did not execute any lease deed with the defendant. Defendant executed a lease deed with some other entity who's not me, because I was incorporated in 1923. 1914, I could not have, I was not present to execute any lease deed. So the finding are two very clear findings. Number one, 1914, no lease deed between the parties. Number one. Number two, 1923, there is no question of the 6 acres of land situated to the south of the golf club being reverted back to the defendant. So in 1923, clear finding, I did not give, or there was no question of me giving 6 acres back because I did not execute any lease deed in 1914, my lord. So till now, my lord, the suit court has found in my favor. Next issue, my lord, issue number 4. Issue number 4 is regarding the 2013 letter. Yes. What is the finding, my lord? Shri Parambi, para 11, Shri Parambi Singh on his deposition on affidavit has stated that on 18 January 2013, the defendant had issued letter in his capacity as Rangba Kaur of the so-and-so clan to take back the southern portion of the suit property as it was not utilized. Suit property is what, my lord? The 10.19 acres as it was not utilized. This court has perused Annexure 3 and found that the defendant has issued letter dated 18th January 2013 expressing to take back into possession the southern portion of the suit property. This court also perused Exhibit 4 and found that there was a communication by the plaintiff club to the defendant that the plaintiff club is concerned only the 10.19 acres of land covered under lease deed dated 1923, and the club does not have any claim to the 16.19 acres covered under lease deed dated so-and-so. Next page, my lord, will see there is no finding on the issue. Issue was whether defendant has issued, suit court has discussed the evidence but not reached a categorical conclusion that yes, the letter was issued. But I would say res ipsa loquitur, my lord, the facts speak for themselves. The letter was indeed issued, my lord. Now, issue number 5 comes, my lord. Issue number 5, I'll just have to take a minute to explain. If lordship goes back to the issues, lordship will see the issue is whether plaintiff club raised any objection when the defendant leased out portion of the 6 acres of land to the Darbar Shnong, Srimati so-and-so, etc., etc., etc. This issue, my lord, arises from the WS which was filed by the defendants specifically one portion of the WS. If Lordship allows me to point that out, Lordship will see in the WS that is at page 33. Relevant page at 35.
Yes.
Now, the first paragraph, I'll quickly go through, my lord. On
17.
Page 35, my lord, of the paper book. Page 35, my lord, that is para 14 of the WS. Relevant portion, page 35. On 9/4/1991, my lord.
Yes, yes.
I'll read them. On 9/4/1991, the defendant leased 18,000 square feet to the Darbar Shnong of so-and-so, where they had constructed a community hall and remains in the occupation till date. On so-and-so, an area of so-and-so square feet was leased to Srimati so-and-so, where she constructed a house and remains in her occupation till date. On so-and-so, an area of so-and-so was leased to Srimati so-and-so, where she constructed a house and remains in her occupation till date. On so-and-so, and it goes on to list out certain areas which apparently defendant has leased out to some other persons. And it's followed by copies of the pattas were also attached. So it was their contention that this leased portion which they have given is within that 6 acres. Now, this two things. Firstly, this was the first occasion where we were informed, we came to know that certain portions had been given out over time to various other persons. Certain portions of what appeared to be our property, our leased portion, my lord. So, number one. Number two, this, after the filing of the WS, immediately we filed title suits, etc., challenging these pattas. Because frankly, my lord, the position on the ground is a little ambiguous, it's a little confusing. They say that they have given out certain portions to various other people. According to them, these portions are within the 6 acres which they got back in 1923. Suit court says 1923, you did not get back anything. So these leased out portions to various people, are they within our property, not within our property? The position is ambiguous. By way of abundant caution, we have filed title suits which are still pending before the lower courts, my lord. So the issue which court was discussing in its judgment arose from this portion, and the issue was whether we objected when apparently the defendant had given out, had issued pattas to these various other persons. As I had submitted, the filing of the WS is when, for the first time, we came to know about the issuance of these pattas. Immediately, we have filed title suits which are still pending. So, if the question is, did you object? I could not have objected when something is done behind my back, without knowledge, without my knowledge, obviously without my consent, my lord. So, this issue was very interestingly dealt by the suit court at page 117, if lordship kindly sees. Page 117, para 12, she discusses issue number 5. Did I object? Para 13, my lord, is the finding. This court has perused Exhibit B, Exhibit so-and-so, 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 Annexure so-and-so, and found that the plaintiff club did not make any objection when the defendant allotted the land to the Darbar Shnang so-and-so, Srimati so-and-so, but only in the year 2013, after WS is filed. They have started making objections in general. In fact, the defendant had allotted the land in the year 1991 to the Darbar Shnang so-and-so, and the plaintiff's club had never raised any objection to this, and according to section 115 of the Evidence Act, the plaintiff are barred by estoppel. Now, my lord, something is done behind my back, and the question is, did you object? If I am not aware of something, there is obviously logically no question of me objecting to that thing, my lord. So, apparently, you issued pattas behind my back. Suit court asks the question, frames the question, did you object when pattas were issued? Naturally, I did not object. Evidence was not required to be led. It is a very logical answer. I could not have objected, my lord. So, suit court found that I did not object. Now, after finding that I did not object, and notwithstanding whatever the findings are on the other previous issues, issue number 6 is decided, again in a very strange manner. Issue number 6 is whether parties are entitled to any reliefs. What is the finding? Page 117. Page 117, para 14. Para 14, my lord. Issue number 6. Under the present circumstances of the case and on the basis of the decisions arrived at the previous issues, it is redundant to discuss on the present issue. The plaintiff is not entitled to release under the present circumstances of the case. Suit is dismissed on contest. Both the parties shall bear cause. Now, my lord, words sort of escape me to describe this judgment properly. My suit was for a declaration that I am holding a lease of 1923. I am a valid leaseholder and consequently I should not be disturbed by anyone, including the defendant. She agrees that yes, you have a valid lease. Issues 1 and 2 in my favor. You have a valid lease, validly registered, etc. And there is no dispute. Even the other side is not disputing that there is a valid lease. Then their defense is addressed. Their defense being that in 1914, there was another lease deed for 16.91 acres. 1923, we gave back 6 acres. Suit court, even on that issue, in respect of the defense, says no. 1914, there was no lease deed between Shillong Club and defendant. And therefore, in 1923, there is no question that I gave back 6 acres to the defendant. The entire matter is resolved, my lord. The entire matter is adjudicated, my lord. However, on the non-issue that did I object to something which I did not know about and finding that I did not object to that, she says, you are not entitled to any relief. So, my lord, this judgment had to be challenged, my lord. So, we filed a first appeal against this judgment, my lord. Here, my lord, I will have to pause and highlight a very important aspect of the matter. When the suit was filed by me, and the WS was filed by them, there was no counter-suit or counter-claim that was filed by the defendants, my lord. So, number 1. Number 2, even after the passing of the first judgment by the first suit court, where the suit court said there is no question that they gave back 6 acres to you in 1923, no cross-appeal was filed by them. So, till date, through the various forums, through the various courts, no counter-claim and no cross appeal has been filed, my lord. So I filed my appeal before the first appellate court. First appellate court, my lord, took up the matter, took various, took several years to process and adjudicate the matter. Finally, my lord, page 149 is the impugned judgment.
Yes.
Now, this judgment, my lord, was passed on 5th October 2023. Now, what this judgment will reflect, my lord, I would say, with all the respect at my disposal, it represents an abject failure on the part of the first appellate court in conducting the duties which lie on a first appellate court, my lord. The judgment is reflective of that failure, my lord. If I can take a few moments to take my lord through the judgment. Lordship, the first page itself, 149, it starts off with the case of the plaintiff in the suit, right at the bottom. Here, in the next few pages, my lord, my plaint has been reproduced very faithfully. So the entire plaint has been typed out and reproduced in toto. Thereafter, my lord, after reproducing my plaint, word by word, page 156. Page 156.
Yes.
Case of the defendant in the suit. So from para 28 of the impugned judgment, the WS of the defendant is reproduced very faithfully. It has been copied again word for word, my lord. Then moving on, my lord, page 159.
Yes.
Right at the bottom, issues framed in the suit. So the six issues which were framed, my lord, has been reproduced again.
Yes.
Page 160, my lord. Page 160, para 42. Evidence reduced by the parties. So, as I had pointed out, two witnesses had come before the court, the first court, one from my side, one from the other side. Their evidence, my lord, has been captured in two lines. Appellant plaintiff examined Sri so-and-so as PW1, while the respondent defendant Sri so-and-so examined himself as DW1. In addition, on the prayer of the respondent defendant, the additional director of survey also submitted a report dated so-and-so. That is the entire reflection of the evidence.
Yes.
Para 43.
Yes.
Judgment passed by the learned trial court. Now, this impugned judgment is passed by First Appellate Court. So, First Appellate Court, the least it could have done is at least reproduced the judgment that is under challenge, or at least the relevant portions of the judgment. Again, my lord, judgment passed with the judgment under challenge in the First Appellate Court has been summarized in two lines again, my lord. After appreciating the evidence on record and hearing the arguments so-and-so, so-and-so, the impugned judgment dated 23/12 so-and-so in title suit number so-and-so was passed and dismissed the suit. Aggrieved by the said so-and-so, we have filed the appeal. Again, no discussion, nothing, no reflection of the judgment.
Yes.
Then, next, heading in the impugned judgment. Grounds of appeal. Now, grounds of appeal, the various grounds I had stated in the memo, in my memo of appeal before the First Appellate Court, again has been reproduced and copied verbatim.
Yes.
Then page 162, my lord, para 44. After reproducing my grounds of appeal, para 144 is possibly the original content of the First Appellate Court. I have heard submissions of both counsels of the parties and perused the case record. Counsel for the respondent defendant relied on the following decisions, a list of decisions. What are these decisions? We don't know. Where are my judgments which I had relied on? No reflection, my lord. Only respondents' judgments have been reflected or reproduced at least. Then next page, lordship.
Yes.
Para 45. Points for determination.
Yes.
The question that is required to be answered is whether the impugned judgment dated 23/12/2015 is sustainable in facts and law of the case. Now, lordship, this is important. I will place the law, my lord, that an appellate court, a first appellate court especially, has to formulate points for determination. And these points for determination invariably are the same issues which were there before the suit court. So you have to reappreciate the evidence as a first appellate court, and you have to reconsider the matter again and reach your own conclusion on the points for determination. They call it in the first appellate stage, but they are the same issues which were seized off by the suit court, my lord. Instead of formulating different issues, or at least copying the issues from the lower court, first appellate court comes up with its own question, a one-line question. What is to be decided is whether the impugned judgment is sustainable in facts and law. Naturally, you're the first appellate court. That is obviously the question that you have to decide. But in addition, you have to formulate points for determination, which was not done. I'll place the law, my lord. I'll elaborate on this issue. Para 46. To understand the rival contentions, let us discuss the evidence on record. I'll just pause. So there was an intention on the part of the first appellate court to at least try and discuss the evidence which was there on record. Now, the next few paragraphs will show, para 47 onwards will show, starting with para 47, PW1 Parambir Singh, in his examination in chief, he deposed First Appellate Court again copies the entire evidence. In other words, in very simple terms, there was no discussion. Again, like the pleadings of the parties, everything was copied word for word, no discussion whatsoever. This was in the case of my witness, PW1. This was in the case of DW1 also. If I can point out. Para 72, page 169 of the memo of the paper book.
Yes.
Para 72.
Para page 172 or para?
1669. Page 169, para 72 of the judgment. Page 169 of the paper book. Para 72. After replicating my evidence, he replicates DW1's evidence.
Yes.
So, my lord, the discussion that is required of any court, including a first appellate court, is clearly absent. He says, let us discuss. He discusses nothing, my lord. He just reproduces everything word by word, my lord. Para 69 may kindly be looked at, my lord. Slightly important, again, in view of what he says later. Now, this was regarding my 1923 lease deed. I had produced a paper mark because the original could not be produced on that date, my lord. What the first appellate court records this, observes, para 69, he was not aware, that means my witness was not aware of the location of original document dated 20th March 1923, and he did not produce before the court. It is, however, in their possession. So we make a categorical statement that on that day I'm not carrying it, but it is there in our possession. And more importantly, my lord, like I had submitted law right at the beginning, there was no dispute between the parties in respect of the 1923 document at least. There was some ambiguity, confusion, dispute for 1914 document. 1923, both parties are of the same view that yes, it is a valid document. Now, moving on in this judgment, page 170. 170, my lord. 170.
Yes.
Page 170 at the bottom, my lord. Discussion, decision, and reason thereof.
Yes.
I'll just spend a few minutes on the next two paragraphs. Para 78. At the outset, it may be stated that the plaintiff appellant in the pleading stated that the Shillong Club Limited is a company registered under so-and-so, and it has its registered office situated at so-and-so. But PW1 Parambir Singh, who is the director of Shillong Club Limited, in his cross-examination deposed that he cannot tell before the court where is the actual location of the 6.72 acres of the main concern of the club in the area of 10.19 acres. It is not a fact that the 6.72 acres is situated to the south of the clubhouse. It is a fact that in the plaint as well as in his evidence in chief, it is admitted that the club had taken on lease a plot of land from the predecessors of the defendant. 79. In his cross-examination, PW1 Shri so-and-so further stated that I have stated in my examination in chief that the Shillong Club was incorporated, a limited company, and registered under the Companies Act 1913 only on so-and-so. It is a fact that the Shillong Club does not know that particular firm or constitution by the name and style of Shillong Sports Club. It is also a fact, as stated in his examination in chief, that the lease deed dated 20th October 1914, which is Exhibit A, is not related to the club in any manner. Para 80. The pleadings of the appellant plaintiff club and the evidence of PW1 is contradictory to each other with regard to an issue of the formation of the plaintiff appellant company. That there is no certificate of the incorporation of the plaintiff appellant company produced before the court to prove as to whether the plaintiff appellant company is a registered company under the Indian Companies Act 1913 or under Companies Act 1956. I'll just pause, my lord. After discussing my evidence, learned First Appellate Court comes to a conclusion that there is apparently some contradiction between my pleadings and my statement, my lord, before the Honorable Court. Fault could be mine, but I could not really understand or see what is the contradiction. Where is the contradiction? Number two, more importantly, the first appellate court comes to a conclusion which is of importance later also in the judgment. He comes to a conclusion that I could not prove whether I am registered under 1913 Companies Act or 1956 Companies Act. My response, very humble response to that is, how does it matter? How does it matter whether I was registered under 1913 Companies Act or 1956 Companies Act? It is nobody's case that I am not a registered company. It is nobody's case that I am not a registered company. I have been registered in 1923. If I was registered in 1923, and this is part of my evidence also, I said in so many words, I was registered in 1923. If I was registered in 1923, obviously, I am registered under Companies Act 1913, not 1956. And Lordship is aware, under 1956 Act, there is a deeming provision that any company registered under 1913 Act is deemed to have been registered under 1956. But leaving all that aside, where was the scope or the necessity of the first appellate court to discuss any of this, my lord, to discuss any of this? Now, moving on, para 81. So after concluding or observing that I could not prove whether I am 1913 registered or 1956 registered, First Appellate Court, para 81, what it says is that it is not known whether the appellant plaintiff company is a company limited by share or limited by guarantee. Again, my lord, again with respect, how does it matter, my lord, whether I am limited by share or limited by guarantee? The nature of the case that I had placed through my plaint had no relation to any of these questions, my lord. It is a settled principle of law. It goes on, my lord. It is a settled principle of law that an incorporated company has a separate existence and the law recognizes it as a legal person separate and distinct from its members. This new legal personality emerges from the moment of incorporation, and from that date, the persons subscribing to the memorandum of association and other persons joining as members are regarded as body corporate or corporation aggregate, and the new person begins to function as a new entity. A corporate personality is a reality and not an illusion or fictitious construction of the law. Maybe, but it has no relation to my case, my lord. It has no relation to my case. There was no occasion or no reason to indulge in all this.
Yes,
Yes,
I think we'll continue
very well.
tomorrow.
Yes, tomorrow may be slightly problematic. Thursday or Friday, whatever.
Or tomorrow is
Yes.
Wednesday. Thursday. So day after tomorrow. Heard Mr. S. Jindal. And counsel for the appellant in part. For the hearing to continue on the next date. This is matter on 27th. For the hearing.
Chief Justice, Lordship. Lordship, I beg to make a mention of item number 3, Your Lordship. Lordship, I pray if this matter may be taken up after a week, Your Lordship.
This is a writ.
Lordship.
What is this matter about?
Your Lordship, we have preferred this writ petition, Your Lordship, against the order passed by the CAT, Your Lordship, sent to Administrative Tribunal, Your Lordship.
How long?
Your Lordship, after 2 weeks, Your Lordship, if it's possible, Your Lordship.
You have no objection. On prayer made by Ms. K. Gurum, direct counsel by the petitioner. The same not being objected to by the respondents, matter is adjourned. This is the same after 2 weeks.
Thank you, Lordship.
On the list, item number 1.
My lord, on the previous occasion, condonation of delay was allowed, my lord.
So,
counsel is not present.